Now, I'm not one to gossip, but I will bring you the tea. Welcome to Chronicle Speaks.
Please, I don't have any time for any gossip now. Eh? Yes.
Look at you.
So we have reached week number 8, Diddy trial day number 33, but let's first recap 32. So before we get into that recap, prosecutors have been painting Diddy as this ringleader of a criminal empire built on abuse, manipulation, drugs, and coercion, not just in the music industry, but behind closed doors with women like Cassie, Jane, Mia, and Capricorn Clark. They laid out disturbing patterns of freak-offs, threats, blackmails with tapes, and allegedly women being groomed or scared into complying. Now, the defense stepped up trying to flip that narrative. They claim this whole case is a mischaracterization of personal relationships, wild lifestyles, and clout chasing. According to them, this isn't a crime ring, it's love, jealousy, and yes, some freaky behavior, but not Rico. They even tried to downplay the videos and texts, saying Diddy's just a businessman in love, not a criminal mastermind. But prosecutors weren't having it. In their rebuttal, they snapped right back, saying these women were coerced, traumatized, and manipulated. That even when they said yes, it came from fear or control, not consent. And they reminded the jury of the violent freak-offs, bribed security, and trauma bonds that kept these women silent for years. Now, the jury has had the weekend off and deliberations will officially start today. Now, the question is, will they believe this was love gone wrong or a criminal enterprise hiding behind fame and fortune? We are going to get into trial day number 33 and so much more, but before we do, please be sure to subscribe to this channel and hit the bell for notifications so you don't miss out on any news regarding this case and so much more. Now let's get back into it. At 9:12, Judge Subramanian enters. He says in case there is anything, we'll bring the jury in for the charge. Garrigo says the laptop is ready. There's a few things we'll finalize during the charge. Judge says just email it to the chambers. All rise. The jury now enters. Judge says, I'll read you the charge. It's long, but I'll try to make it interesting. You have now all heard the evidence in this case, as well as the final arguments of the parties. I will instruct you on the law as I give it to you. The evidence is the testimony, the answers, and the exhibits. Arguments are not evidence. You are the sole and exclusive arbiters of the facts. What is a reasonable doubt is based on your common sense after carefully weighing all the evidence. You just weigh each witness's credibility, the truth, and the importance of their testimony. Size him or her up. You must decide. Sean Combs has been formally charged in an indictment. An indictment is not evidence. Count 1, charges from 2004 to 2024, a racketeering enterprise. Count 2, from 2009 to 2018, SCEX Trafficking of Cassandra Ventura. Count 3, from 2009 to 2018, transporting individuals including but not limited to Ventura for the purpose of prostitution. And then count 4, from 2019 to 2024, SCEX Trafficking of Jane. Count 5, from 2019 to 2024, transporting individuals including but not limited to Jane for the purpose of prostitution. Each count is separate. For attempt, the U.S. must show intent and a substantial step taken. Mere intention does not amount to an attempt. Aiding and abetting means knowingly doing some act to aid or encourage a crime to be committed. For RICO, the U.S. must prove that from 2004 to 2024, there was an agreement between 2 or more individuals for a racketeer enterprise and that the defendant joined the agreement and committed at least 2 predicate acts. The U.S. must prove a mutual understanding to cooperate. You may infer its existence from the circumstances of this case. Actions may speak louder than words. You may consider the acts of all of those you find to be participants. If you find that the Combs enterprise existed, you must find whether it continued in a substantial similar form from 2004 to 2024. The people can change. As the defendant being a member, he had to know of the existence of the enterprise. The U.S. alleges 8 predicate acts such as kidnapping, arson, bribery, witness tampering, forced labor, SCEX trafficking, transportation for prostitution, intent to distribute narcotics. Now, the U.S. has to prove 2 offenses within 10 years. Kidnapping does not occur if the victim consented. Consent may be withdrawn. Arson under California law means that the conspirator set fire to or caused the fire willfully or maliciously. Bribery under California law requires that a conspirator gave or promised to give a bribe to a person given or about to give information to law enforcement to unlawfully influence it. Now let's get to witness tampering. Violation 18, section 1512b3. It does not matter if the subject of the threat is in fact fearful. Only a threat is required, but it must be knowing. For forced labor, violation 18, section 1589a requires use of force or use of force of physical restraint. A person may withdraw consent and it may become forced labor. SCEX Trafficking will have the same definition as in count 2 and 4, and transportation to engage in prostitution, the same as count 3 and 5. Next is distribution of narcotics, including this long word that you see, knowingly and intentionally. Distribution means actual transfer to deliver to another person. For possession, physical custody is not needed. Control is enough. Now, RICO has a 5-year statute of limitation. You must find that it continued past 2019. If you find that the government has not proved this beyond a reasonable doubt, you must find the defendant not guilty. Now on to SCEX Trafficking, count 2 and 4. Transport means to take or convey from one place to another. Reckless disregard satisfies the statute. The deliberate closing of eyes, you must be unanimous on at least one specific instance of SCEX Trafficking. On count 3 and 5, knowingly transporting or arranging for the transportation of an individual for purposes of act of prostitution, buying or arranging a ticket is enough. Prostitution does not need to be the main purpose. Now, prostitution is engaging in sexual activity for money or its equivalents. You must be unanimous on at least one specific act of transportation with intent to engage in prostitution. On venue, the U.S. must prove at least one act occurred in the Southern District of New York's 8 counties. Now we're in the home stretch. Now, in weighing expert testimony, you should not accept it just because I allowed it. The testimony of government officials are not worth more or less weight than any other witness. Witnesses given immunity should be examined with greater care than ordinary witnesses. Charts and summaries, demonstrative aids are not evidence and will not be available to you in the jury room. Certain witnesses were permitted to be identified by pseudonyms that should not affect your evaluation of their credibility. The defendant was not required to testify, and if he chooses not to, you must not draw any conclusions or attach any significance to that decision. Voluntary intoxication may negate the intent requirement of RICO predicates. Uncalled witnesses, you have heard names of people not called as witnesses. Each side had an equal opportunity to call them. Do not speculate or consider this. Any notes you took are only for you, not outside reading. You are to consider only what was presented within the 4 walls of this courtroom. You may not communicate about this case, including on X, Instagram, or YouTube. If you see this, tell my deputy. Do not be swayed by bias or implicit bias. These hidden thoughts can impact what we see, what we hear, and how we remember it. You will now retire to consider the case. Each of you must decide the case for himself or herself. After deliberating, your verdict must be unanimous. If you are divided, do not report the specifics. Your foreperson will send out any notes and any verdict. Any communication with the court should be in writing. The alternates do not have to be here, but give your phone number to my deputy. You may be called to replace a juror. You will be called when a verdict is reached. The alternates are 234, 247, 292, 321, and 330. Please accept my heartfelt gratitude for your service over the past 2 months or even more. My deputy will provide my personal contact info. I could give you a tour of the courthouse. The alternates leave. Judge says, here's the verdict sheet. Only if you find the defendant guilty of count 1, answer as to each predicate was proved or not proved, and whether the SCEX trafficking involved Cassie, Jane, or both. Counts 2, 3, and 4, and 5 indicate your verdict as either guilty or not guilty. From now on, your schedule is your own, and you will be provided with meals. Now the marshals will swear you in. Done. Now the jurors can head back to the jury room. All rise. Now the jurors exit. Prosecutor Johnson says, we object to including the subject lines of BlackBerry messages like "I'm so horny." Estevao says it is common for exhibits to include subject lines. BlackBerry messages are more akin to emails than to text messages. Judge says let's have only neutral lists go to the jury. I'll trust the parties to provide an appropriate laptop to the jurors. I'm going to stick around for a bit, but we'll just stay here as long as they wish to deliberate. At the end of the day, we'll bring them back in. I appreciate the collegiality on both sides in this case. Anything before we adjourn? Prosecutor Comey says no. Can we go to another floor of the courthouse? He says, just give us your cell phone numbers. And court is adjourned. While court is adjourned, at least for now, Sean Combs is still in the courtroom. His family members are standing in the second room, and Combs goes back to speak with them, holding his hands behind his back, then back to the table, staring at a laptop. Now we have an update. At 11:48, the judge says we have received a note from the jury. They have elected juror number 5 as the foreperson. It is signed by juror number 5, and there is an agreement on the laptop. It will be taken in to them. Now we'll have an even longer break. Combs is then taken back to his holding cell, and his attorney Driscoll is steady typing away on her laptop. Now Combs is brought back into the courtroom, and his lawyers are huddled up behind him in discussion. There's been another note received by the jury. At 1:27, the judge says we received a note from the jury that we have a juror number 25, who we believe cannot follow your instructions. I would like to meet with the court about it. Judge says I suggest I ask for more information. Prosecutor Comey says, may we have a moment to digest what your honor has proposed? This is very sensitive. Agnifilo says, I suggest we just tell them it is early, you're getting started. If there's a further issue, please let us know. Comey says if we go that route, we suggest instructing the jurors it is important not to include any information about what is going on in the jury room. We are looking at U.S. versus Baker. Judge says confer on a response. I'll stay here. Now, the case that Comey cited, U.S. versus Baker, Second Circuit held removal of the juror who refused to participate in deliberations despite her obligations as a juror. Now at 2:02 p.m., the judge says, do we have an agreed upon response? Agnifilo says, no, we do not. Comey says Ms. Slavic has emailed it to the chambers and it's currently not in the docket. Judge says, do we have the defense's proposal? Comey says it will be in Ms. Slavic's email. Judge says I would prefer to have a neutral response like the government's draft response. That's the one I'll use. I'll put it on the court's letterhead. Agnifilo says there is no suggestion the juror will not follow instructions, so our proposal is more insert. Judge says I don't want to suggest to the jury that there's any particular time they must deliberate. I don't want to tell them that because they just started. I'm going with the government's version. We will print that out and send it to them. So 1 hour into deliberations, the jury sent a note saying that they were worried that one juror could not follow instructions. Now that juror is allegedly a man with a PhD in molecular biology and has a strong European accent. The judge just sent the note back that says, I received your note. I remind every juror of their duty to deliberate and their obligation to follow my instructions on the law. With the instructions in mind, please continue deliberating. The note also instructs the jury not to reveal any specifics about their deliberation in any future notes. So according to CNN, there is a wild card on the jury, and that is significant. It happened incredibly quickly. There's a lot of give and take, back and forth. Now, deliberations can get incredibly heated, and that's part of the process. For the jurors to say that one juror is not going to follow the judge's instructions, this is quite notable, especially at this early stage of the process. According to the note, the foreperson also asked to speak with the judge or to have juror number 25 interview, which would be the next step in the process. And then it's really up to the judge to decide, all right, I don't know if this juror could continue to deliberate, but they've already started, so there's already good grounds for any type of appeal by the defense should there be a conviction. This scenario is a possible massive headache at this early stage of the game, especially since the judge already dismissed a juror earlier this month. Juror number 25 is a 51-year-old male who works as a scientist who lives in Manhattan with his domestic partner. On June 16th, the judge dismissed juror number 6 over the juror's inconsistent disclosure about where he lives. Okay, at 4:49, Sean Combs has been brought back into the courtroom by the U.S. Marshals. His lawyers are gathered around looking at a piece of paper. Another note has been sent in by the jury. Okay, the note from the jury says we have two letters, notes from the jury. If an individual asks for a controlled substance and the person hands it over, is it distribution? And the second letter says they will end at 5 o'clock today. I suggest we respond by pointing them to the jury charge. So it's currently 5:06. I want to leave you with this guy who explains a little bit of RICO and how it is to be a defense attorney waiting for the jury to come back with a verdict. Take a listen to this.
Good, freakishly early Monday morning. I hope everybody had a relaxing, sleep-filled weekend. I guarantee you slept better than Mr. Combs. Today, the jury is going to get the case and they're going to render a verdict. A couple of interesting things before you get there. One, the judge is first going to tell the jury the law on the case. You've heard everybody say that's the charge on the case. What the judge is going to say is, this is the law. Not the way you want the law to be, but what I tell you is the law, whether you agree with it or whether you disagree with it. Why is this a big deal? Again, I've mentioned I've been doing this for 25 years, tried well north of 100 cases. I have never seen a situation where closing arguments end on a Friday and they stop. And then we come back on Monday and get the charge on the law. Why is that such a big deal? It's a big deal the last thing the jury hears, but everybody talking about this great closing argument by the defense, the great by the prosecution, jury done forgot all that shit. So all they're going to hear is the judge saying, this is what the law is. Now go back there and make a decision. That aids the United States of America because the law in this charge is oddly specific. The judge is going to say what the law is and say, if the government has met the elements and this is the law, then you convict. And that's the entirety of the instruction. They give them the verdict form and make a decision. It's sort of like if you go to somebody's house and you're playing Uno and they're just like, man, you can't put a draw two on a draw two. It's their damn house. You follow their rules, no matter whether you like them or not. Number two, something that people have talked about it, but I do find this interesting. One of the reasons defense attorneys, me, all of us hate RICO is one, it's so incredibly confusing. But a couple things. One, as lawyers, we are not allowed to tell the jury the penalty somebody is facing, and you're not allowed to say the reason why the United States of America or your state is going after somebody. In RICO, if the United States is able to prove, meaning the jury finds him guilty of RICO, then the United States can go back later and say, Judge, that is a corrupt organization. And its entire purpose of crime. So it's up to us, it's incumbent of us at the United States of America to dismantle this organization. Take it down brick by brick. And we need to get all their assets and all their money so we can use it to fund the other stuff that the United States does. Why do you think the United States has so much money to combat crime? Because they keep taking it from individuals they convict of crimes. Don't you think it would have been interesting for the jury to know, you know what? They're targeting that billionaire, Mr. Combs, and taking his organization so they can get all of those funds. That's one of the things the defense attorney was trying to get into by saying they're targeting it, and the judge shut it down. It's like, nah, you ain't getting into that. And they were like, bad boy, come out and play. And the judge says you're not getting into that. So that's one of the things that's very fascinating when you look at a RICO conviction and why we don't like it, because the overreaching power of what they can do if they get that RICO conviction. Then, finally, two things. The last two things we've been asking a lot. One, Mr. Kip, do you wear such bright suits in court? You damn Skippy, try and stop me. And two, most importantly, someone's asked, do you still get nervous? Most defense lawyers will tell you, you don't get nervous giving openings, you don't get nervous doing closings, you don't get nervous doing cross-examinations. None of that stuff creates all of these crazy nerves. The nerves come when you're sitting at lunch, everything's done, right about 11, 12 o'clock, 1, 2 o'clock. Every time that phone rings, who that is? Who that is? Every phone ring, and all of a sudden, Jerry's got a question. You're like, son of a bitch. Every time the phone rings, you're going to start getting nervous. But the most nervous that the criminal defense attorneys in this case will be is that, all rise. I've been told that the jury has a verdict, and they're walking in. Will the defendant please rise? His booty hole going to be tight. Well, for the first time, his booty hole will probably be tight. It is the most nervous, the most nerve-wracking you'll be as a defense attorney as you're waiting that. And it's going to feel like an eternity as the judge is reading the form. It looks correct to me. And then he has Madam Clerk publish a form. And then the clerk stands up and says, in this case of the United States of America versus Sean Combs, as to count one. That's the most nervous defense attorneys and the chocolate demon will possibly be in this case. People ask, what do you think the verdict will be? I don't know. I really don't know. And anyone telling you they know what that jury is doing is completely lying. I do think it favors the government tremendously that today, all they're going to hear is the charge and go back there and ask to render a decision. Turn the TV off. Turn the TV off. Here comes the sun. Take that, take that, take that, take that, take that. Taking a trip, as a matter of fact, a little later today. Can you guess where I'm going? Cheerio. And then someone says, what type of jury would you have picked on this case? I think I might send you a video of what I would have picked.
What I need to do is hear from you. What do you think about everything currently going on in the world of Diddy and the verdict watch? Leave a comment and you know how we do. We'll talk about it down below. Talk to you guys later. Bye. Thanks for watching, but before you go, don't forget to subscribe to this channel, like this video, and hit the bell so you don't miss out on any of my new episodes.